So now this chapter just kind of flows in with the chapter prior to it. So 3 key players in a corporation of any large size. And again, we're starting more to talk now about publicly held large corporations. Who are the 3 players? Shareholders. Who else? 3 big groups, if you will, within a corporation. Board of directors, shareholders, and corporate officers, right? So that's what this chapter is about, understanding how they fit into the corporate structure, right? This is a chapter on corporate governance, right? So who are the shareholders? Well, the shareholders are the owners of the corporation. They're not, by that title alone, agents of the corporation, which means that they cannot bind the corporation to contracts. If all I am is I own 10 shares in Apple, great, I'm a shareholder, and Apple shares are doing mighty well, so that's good. But that's not to say that I can go around and say, have any say in how Apple runs its business. That if all I am is a shareholder, I can't do anything more. But shareholders are often employees. Shareholders are often officers. So that's different. But if all I am is a shareholder, I am not an agent of the corporation. I'm simply an owner shareholder. But what I do have a right is, if I own common stock in that company, I have the right to vote on certain things, such as fundamental changes in the corporation, which may include things like, should the corporation sell off part of its assets? Should it agree to a merger with a competitor, or things like that? So as an owner, I have some say. I call this mini democracy in a corporation. Shareholder meetings, right? Corporations of large sizes have annual shareholders meeting, and most of them are rah kind of thing, and that's fine. I mean, a couple of years ago, out of curiosity and through friends and so on, I said, I've been teaching business law for all these years. I haven't gone to a shareholders meeting. I should go to a shareholders meeting. So I went to Johnson & Johnson's in-person shareholders meeting in New Brunswick, and it was fabulous. It was sort of, I got some goodies, which is always fun. But more important than that, I got, yes, I know how the process works, and, one can engage in a shareholders meeting via virtually, and I've done that. But to be there in person, to feel some of that energy, and so on. And, for those of you that might own a few shares or so on, I'm not, if it's a shareholder meeting that's in your vicinity, go. It's, that's the best sort of thing that you can kind of gauge in terms of how, a lot of it is staged, a lot of it is predetermined. I mean, all of these votes have been taken already, and they're just announcing, but to still see it played out is kind of interesting. So yeah, corporations have an annual meeting, and a lot of it is to elect a board of directors, and we'll talk about board of directors in a few minutes, and so on, and how they get elected, and does everyone come up for a vote at the same time? Likely not. But that's when shareholder votes they've already been done and tabulated, but are announced at the annual shareholders meeting. And by the way, corporations sometimes called special shareholders meeting, and this typically is because of something that's too important, and it can't wait for the annual meeting. For example, what if they're engaging in a friendly merger with another company, right? I mean, that cannot wait until the April 1st meeting of the board of the annual shareholders meeting. Or what if it's a smaller corporation and they just want to amend their articles of incorporation, right? And that might require a special meeting of the shareholders, because under the bylaws, under the articles, shareholders get to vote on that. And the only way to do that is to call a meeting, and it may not, again, meetings are often virtual. Shareholders often vote their shares by proxy, which means that they just cast a vote, a mail-in vote, I should say. So again, these are corporate formalities that corporations of a legitimate, reasonable size need to engage in. In order for a shareholders meeting to take place, corporations need to advise shareholders when that is. And again, this is becoming more and more automated, right? I mean, these days for anyone that owns a few shares, they're going to get an email notice, they're going to get, nobody's wasting paper. Back in the day, they had to send out, all this paper and all this information on, the 10 people that are seeking to be on the board, their qualifications, and, to the extent that the shareholders want some resolution involved. No more. We're green. We're saving trees. You'll get an email. You own shares, and by the way, you can own 10 shares in Apple and get the same notice that someone, who owns a lot more would get. And it's basically telling you this is the time, this is the place, this is where the meeting is, and this is what's on the agenda. If you want to hit know more, click here, go to this website or whatever, right? But you can't vote on something if you haven't been given the tools and the information in order to do that in an informed manner. So that is a requirement under state and federal law that the corporation has to provide its shareholders that notice and that information. And as I said a few minutes ago, voting, it's nice to go to Johnson & Johnson and say rah rah in New Brunswick, but voting is really done by proxy, which means a shareholder, if they want to exercise their right to vote in that corporate matter, will vote by proxy, meaning giving someone else the ability to vote their shares by sending in how they want those shares to be voted. And you can vote electronically, you can vote by mail-in or whatever method that the corporation allows you to use. Who gets to vote? Depends. I mean, if it's an April 1st meeting and the votes have to be tabulated, they're going to pick a cutoff date. You had to be a shareholder by a certain date. For example, I don't know, I'm just picking a date. You had to be a shareholder of record by December 31st, 2014 in order to vote for the shareholder meeting on April 1st, 2015. Why? Because you need 3 or 4 months to kind of tabulate, send it in, and so on and so forth. So that makes sense. And, obviously the corporation has to have that information. They have to have the names, addresses, emails of shareholders on record in order to send them that information. Another word that we need to get familiar with, quorum. Quorum. It's right there on the slide. We'll see it come up with directors. We also see it come up with shareholders. Quorum is sort of the minimum number of shareholders that are represented for there even to be a vote that counts, right? So for example, if there are, in our example, we had 400,000 outstanding shares that could vote, right? A corporation could say, well, you need to have a minimum of those shares represented either in person or by proxy, meaning we have to get back at least a majority, 200,000, for the vote to even count, right? Because we all know as citizens of a country, we don't always go out and vote in elections. We should, but we don't. So same thing, just because I own shares doesn't mean I will vote my 10 shares in Apple. I will say, ha ha, like I care. I'm not even going to bother. But the corporation has to, for a vote to be legitimate and to have, to have any value, it has to meet quorum, meaning that at least a majority, for example, constitutes a quorum. So if we don't get 200,000 shares represented, the vote doesn't even count. That rarely happens because a majority will be represented. But that's what we mean by quorum, okay? At least that many votes that came in, and out of that, did we get a majority to elect a board of directors? Did we get a majority to, elect members to the board of directors or to authorize a corporate transaction or whatever the case might be? With voting, I don't get into a whole lot of detail, but there are, in large corporations, different ways under which voting happens. And that really the goal here is protecting minority shareholders. And what do I mean by minority shareholders? Well, if there's a block of shareholders that feel strongly about whether or not a particular individual should continue to be on the board of directors, or, for example, shareholders sometimes will put up something that they want other shareholders to vote on. And it's often things like shareholder resolutions. We feel strongly that we should not invest in a particular country because of human rights issues. And this was a common thing. I mean, think back to decades ago, apartheid in South Africa. That was a hot button issue. And, you know, a lot of shareholders and companies said, we won't do business in South Africa because South Africa treats, you know, majority of its population as second or third class citizens. And this was a big deal in the 80s and so on. So, you know, so shareholder resolutions, and they want, you know, the only way a company will or will not do something, I mean, it may cost them money. It's not like people are, you know, supporting apartheid, but they basically want to do business anywhere where they can make a profit. You know, why shouldn't we do business? I mean, isn't, you know, and we talk a lot more about, well, what is the corporation's purpose? To raise shareholder value. And if we start picking and choosing how we do business, we're going to, you know, I'm giving you the other side, dilute that shareholder value. But all of that aside, the reason I sort of bring that up with voting is, how do shareholders that may not have the majority voice get their votes counted as being more? And there are different ways in voting, cumulative versus non-cumulative voting. You know, can minority shareholders lump together their votes and then use them all to vote for one particular candidate or vote out one particular candidate? That's, you know, that's cumulative voting versus non-cumulative voting. No, you're not responsible for all these details, but it sort of, it gives you a flavor for how very complicated corporate law can be, and how bylaws and voting rights and all of this and voting trusts and cumulative versus how they figure in. It's not as simple as one shareholder, one vote often. It's a lot more complicated than that. And again, under securities laws, all of this is governed under federal securities law. How a corporation goes out and solicits a vote, and you know how those votes are tabulated, and so on and so forth. It has to be totally, for lack of a better word, on the up and up. Otherwise, there are federal securities laws to deal with. So, you know, the corporate governance structure is rather complicated and intricate. And as I said, again, you know, what it takes to have even a valid vote means, for example, your articles or bylaws will say, you know, how many shares have to be represented. I mean, typically that's a majority, but you could have a supermajority. You could say, no, for certain types of things, for mergers or for other types of things, we want a supermajority. What is a supermajority? Define it. 60%, 2/3. You know, again, recognizing that you're locked into those numbers, right? So corporate, you know, I mean, this is sort of a strategic kind of a thing that corporations need to think about. And, you know, again, we're not getting into too much voting. I mean, you know, shareholders, when they vote by proxy, are basically transferring their votes that they mailed in, for example, and put into a voting trust, meaning that someone will vote these in their interest, meaning according to how they voted, and those are referred to as voting trusts. So again, we're talking about a lot of formality here, but the takeaway really here is, and we're not going to get into shareholder voting arrangements and so on, is that shareholders have one very, very significant right, which is they get to have a say, you know, at least annually, but sometimes more often in terms of the direction of the company, the matters that come up before the, you know, that the board puts up for vote, whether it's, you know, how the company operates in the future, where they choose to have investments, who is going to represent them on the board of directors, and so on. And that is a significant, significant right that shareholders have. All right, so moving away from voting rights, what about the ownership interest, right? So shareholders own shares in a company. And, you know, if they're large publicly traded companies, my 10 shares or 100 shares or even 1,000 shares in Apple, it's not a lot. It's not a lot because we're talking about millions of outstanding shares. But now think about smaller companies, smaller corporations where the shares are held by fewer shareholders. Right now, think about closely held businesses, like that Tabasco example that I just gave in earlier. So here, you know, companies are set up, they don't want to be publicly traded because they want to have more control over their ownership interest and more of a say in how they run their business. They don't want shareholders telling them what to do. Well, you know, general shareholders, they want to have a core group of owners. Here, what oftentimes companies do is they have what are called agreements among the shareholders that give them right of first refusal. Well, what does that mean? So pick a company. Let's say a company has 100 shares. I'm just making an easy number, with 10 shareholders. Okay? 10 shareholders, 100 shares, everyone owns 10 shares, right? When you have what is referred to as a right of first refusal, it doesn't mean that someone's going to hold a gun to my head and say, you have to own these 10 shares forever. If you don't, you know. No, I mean, it's a free country. I'm investing in a business. I do have the right to sell my shares. But if I have the, you know, if I'm locked into a right of first refusal, what that means is that as a selling shareholder, I have the obligation, the legal obligation, to offer my shares for sale to the other 9 shareholders before I go outside. Okay? So that means that the other 9, first, any of them, all of them, however, can buy me out. And they might say, well, whoa, wait a minute. If she is leaving out, we don't want someone else coming in. The 9 of us will step up and buy her out. You know, one person can buy all my 10 shares. All of them can buy 1 share or each, or whatever the case might be. That is a right of first refusal. If they choose not to do that, then, and only then, can I go outside. Okay? That is called a right of first refusal, and it's almost always negotiated among smaller companies. Along with that right of first refusal is something called a buy and sell agreement. A buy and sell agreement. And what is that? That's an agreement that requires selling shareholder to sell their shares to the other shareholders or to the corporation at a particular price. That's all it is. So a buy or sell agreement can leave open the price. I mean, how do I know what I want to sell my shares at? You know, I don't know what they're going to be worth in 10 years, perhaps, when I decide to sell. So it's sometimes very difficult to say, okay, I give the right of first refusal, but now we're going to put a price on those shares. So sometimes a buy and sell agreement will just, instead of naming a price, it will have a methodology. It will say that not only is there a right of first refusal, but the selling price of those shares shall be the market value, or, you know, if we're going to agree to this kind of valuation and 10% premium or something like that. So oftentimes that's what you're doing. You have an agreement where you're going to offer the right of first refusal to the other shareholders, and you're going to lock in some kind of legitimate mechanism for valuing those shares in the future. Everyone with me? And preemptive rights are kind of similar to right of first refusal. Preemptive, right? To preempt something. So preemptive rights basically give a right to existing shareholders the option to buy more shares when the corporation decides to issue more shares to raise more money. So stay with me for a minute. For example, corporation has 1,000 shares issued. And again, I'm going to make it easy. And they have 10 shareholders, and all those 10 shareholders have 100 shares each, right? Corporation is authorized to issue more shares. Corporation wants to raise money. Corporation is very successful, and they think they can go out and sell 1,000 more shares. Great. If I'm an existing shareholder, why does it bother me a little bit? Or why might it bother me? It's dilution is the exact right word. It's diluting my interest. Because all of a sudden, I'm no math expert, but I do the math in my head and I say, wait a minute, today I own 10% because I own 100 of 1,000. Tomorrow, when they have 2,000 outstanding shares, if I don't buy any more, I'm only going to own 5%, right? That's going to affect how I vote. It's going to affect, wait a minute. If I have preemptive rights as a shareholder, what that allows me to do is that any time that the corporation issues more shares, they have to first come to me and say, you have the right to buy more shares that we're issuing up to the amount that keeps your interest at the same level. You don't have to, right? Failure to exercise your preemptive rights. I'd love to, but I can't afford to buy 100 more shares, meaning that the shares can now be sold to somebody else, but at least I have that option. And again, those are things that are negotiated into articles of incorporation, bylaws, and so on are set forth. Do certain shareholders have preemptive rights? Do they have, do the other shareholders have right of first refusal, and so on? And all of this is, again, to keep the shares ownership in few hands, and if you're a shareholder, to allow your ownership interest not to get, quote unquote, diluted, meaning get lessened over time. We talked about dividends a little while ago. If I'm a shareholder, one of the advantages to my ownership interest is that I could get a dividend. And what is a dividend? Well, a dividend is when the corporation distributes profits to me, at the end of the year, at the end of the fiscal year, whatever, because they've been profitable and they're going to actually, in addition to the shares I own, I'm actually going to get, a dividend, a share of the profit for that particular time period. Is everyone allowed a dividend? No, not necessarily. I mean, you might have preferred shares that dictate that a dividend come along, but generally a dividend is declared at the discretion of the board. Does the board feel that it is good for the corporation to distribute profits, or do they think it's better to reinvest in the business? It depends. And a dividend could be monetary, or it could be a stock dividend, meaning that if you own 100 shares, you're going to get 10 more shares, right? Or it could be a monetary dividend. So again, it depends, and to the extent that if it's a stock dividend, it is in proportion to your existing interest, which means that from that pot of money, if you own 100 shares, you'll get a proportion of that. If you own 1,000 shares, you'll get more, because you own more, you get more of a stock dividend. It's a democracy. That's what a corporation is, right? Well, we hope. How could you have a class in business law and not talk about a lawsuit in one way or another? Derivative lawsuits. And this is sort of a particular type of a lawsuit. It's a right that shareholders have that is not often exercised, but it could be in certain circumstances. So what is a derivative lawsuit? A derivative lawsuit is a lawsuit that shareholder or shareholders typically bring against whom? Against the very corporation that they own. No, I said that wrong. Not against the very corporation that I own, against the very, not against, on behalf of the very corporation that they own. Derivative is like, a right that you have where the primary party is not bringing a lawsuit. So let me start over. What is a derivative lawsuit? It's a lawsuit brought on behalf of a corporation where the corporation itself is unwilling to do so. And you say, well, wait a minute. The corporation is owned by shareholders, and you're telling me that certain shareholders are bringing a lawsuit, but aren't the shareholders the corporation themselves? When does this happen? Well, this typically happens, for example, where, remember, a corporation is owned by a lot of different shareholders, right? And the corporation acts not through its shareholders, it acts through its board of directors and its corporate officers. And you oftentimes sometimes find a vocal, aggressive group of minority shareholders that say, wait a minute, this is, this corporation is running amok. We have a legitimate lawsuit against someone that maybe it's an auditing firm, maybe it's a third-party vendor, whatever the case might be, that we think that has done wrong to the corporation and is liable for damages. And they sometimes argue, well, the corporation is not acting in the best interest of the shareholders because by failing to bring a lawsuit, they're acting in their interest because they actually have ownership interest in that, or are buddy-buddy with that auditing company, or whatever the case might be. So we think that it is in the corporation's best interest to act, and we, the shareholders, are going to bring a lawsuit on behalf of the corporation, particularly where the directors and the officers refuse to act. So, this is a complicated legal scenario. You first have to go to court and give an opportunity for the corporate governing body, the directors and the officers to do so. If they refuse, the court first have to look to see, hey, is this in the best interest of the corporation? I mean, you can't decide a case right then and there, but based on the facts, does it seem like the shareholders might have a cause of action against some third party? And if that's the case, then a derivative lawsuit is allowed to proceed, right? And here what happens is that to the extent that the shareholders do win, any recovery doesn't go to them, it goes to the corporation. And in a derivative lawsuit, the shareholders do not have to pay their own expenses. They're expecting the corporation to pick up the legal tab there. So complicated, convoluted, this is where the board and usually a minority shareholders are butting heads quite a bit. And, and they're suing in the name of the corporation, but they're doing something that perhaps the board and the officers should have done in the first place. It does not happen often, and oftentimes it gets settled. And it's oftentimes a tactic. It's a negotiating tactic for the most part. So it's a lot, we're talking about big boys playing in the big leagues, essentially, right? So yeah, derivative lawsuits are not common, and they're often a strategy, a tactic to get the board and the officers to pay attention to a very vocal minority shareholder group. I love the next slide because it sort of inspired the name of the piercing the corporate veil, right? I mean, it's like mythology, we're like, it's like Lancelot or something. But, you might say, who comes up with these names? Piercing the corporate veil. This is terminology that over time has been in case law, as judges write their decisions and so on. So we talked about limited liability of shareholders, right? Corporation is a legal entity. And if the corporation's assets are not enough, too bad, right? Because shareholders have limited liability. In some instances, and this is an exception to that general rule, courts will allow piercing, like if you take a sword and you pierce a veil, meaning going through the corporate structure and actually holding shareholders liable. Now, does it happen often? No. It happens in egregious, outrageous circumstances where a shareholder so dominates a corporation and, more importantly, uses it for improper, let me just even say fraudulent purposes, such that the courts have to, out of an interest of fairness and equity, have to disregard the corporate entity and actually hold the shareholder liable for the corporation's debts and obligations personally. And sometimes it happens when there's very little capitalization, meaning you're investing in a business, but you're putting hardly any money into it. And you're just abusing the corporate structure for your personal gain as shareholders within that corporation. And that's typically when it happens. And that's sort of what this case, this Northeast Iowa ethanol case, which sort of had this convoluted set of facts. I think both cases in this chapter had very convoluted facts. But the point here was, I think there were a bunch of farmers that were looking to attract capital, and they put up some of their money, and then they got this corporate shareholder, investor. But does anyone want to help me out here?
I think it was just
one guy.
Yeah.
And
he was calling himself a corporate.
Correct.
And he took their money, said I'll invest it, and
Defrauded them.
then he sort of like mixed it with his own,
He was a crook.
and he lost it.
And he lost it all. It was a crook, and it wasn't like it was bad business judgment. It was his, he put himself up as a legitimate business front, but at the end of the day, the very reason that he formed this corporation was to defraud investors just like this one. And the court said here, again, this is very factual, based on, they said that this individual has money, and they're using the corporate structure to basically defraud and try to say, well, too bad. I'm just a shareholder. It ain't going to work. And that's really what happened here. The court said this is a type of a case where we're going to look through this individual's structure as a corporate entity and actually hold him, the shareholder, liable personally and pierce the corporate veil because of fraud, because of wrongdoing, because of commingling, because of undercapitalizing, and all of those things that would apply in order for that to happen. So it didn't happen in the Barr case that Ronald talked about because there was no fraud involved there. It was an unfortunate event, but here there was, and that, you know, and that's sort of the distinction.
One thing the case talks about is the amount of money, the initial capital
That he put in.
that he put in, and the way he mixed it up in his own personal.
Yeah, yeah.
But in a case where you have maybe an equal share of capital input, and you mixed it up in your funds, and you ended up defrauding
Yeah.
for some reason.
What? Yeah. So the question is,
Yes.
yeah, the question is, okay, what if there's, you know, here there was commingling and undercapitalization, but what if it wasn't undercapitalization and just commingling and perhaps defrauding? You know, do you need both? Do you need one or the other? And the answer is, there's no bright line rule. You have to look at the facts of a particular case. You know, just undercapitalization may be enough. Just commingling may be enough. I mean, at the end of the day, was the corporate structure abused? And the rest of are just building blocks to get you there. Okay. So this was, you know, oftentimes we see black and white cases, and this seemed like a perfect black and white case. The harder cases are where there's a lot of gray, you know, where you have a lot of, you know, again, you're taking testimony and evidence. Was the intention to defraud? Was it, you know, well, could commingling sometimes happen inadvertently? And just the very fact that you inadvertently commingled because you are an unsophisticated individual shouldn't be reason enough to pierce the corporate veil, barring more sensational kind of facts. Yeah. All right, we're done with shareholders. We're moving on to the board of directors, the next key set of players, right? Board of directors are whom in a publicly traded company, well, or even in a non-publicly traded company? They're sort of the advisors, the policy makers, a panel of decision makers. When I say a panel, I mean more than one. Obviously, I'm talking about, you know, you're talking about a few people that are typically elected by shareholders and are actually paid for their services. Some don't take compensation, some do. And they're, you know, I mean, they're taking on liability as well. I mean, they're acting on behalf of a corporation, and we'll talk about liability over time. But, you know, what they're doing is setting the policy for the, you know, what should we invest in? What should we do? Where should our operations be? And so on and so forth. How do they act? They act by adopting resolutions. They often act based on recommendations from corporate officers, and so on. And that's why during meetings is when their policies are being announced, they're often going out to shareholders for approval where they have to. We want to merge, we want to engage in, or we want to take over a company. Are you with us, shareholders? Of course, as a member of a board, the members of the board have absolute right of inspection of all corporate documents, right? They're sort of, you know, it's corporate board of directors here at the top. It's officers that sort of work with them. It's shareholders, I don't want to say at the bottom, but they're often not engaged in the day-to-day business of the corporation. They're called upon as needed under the bylaws, under the articles of incorporation, when they have a voting interest in some of those activities. So again, for people that understand visual, right, shareholders are owners of a corporation, board of directors make the policy decisions, and the officers of the corporation actually help. They're not depicted here in carrying out the day-to-day activities, but when you sort of think about it in this perfect sort of scheme, it's the shareholders that actually have a say on who gets to be on the board, right? They actually elect the individuals on the board. And speaking of that, how does one wind up on serving? I mean, it's a very prestigious position. Oftentimes you find that people that run other companies are actually on boards of other companies. They're sought after. You find experts in their particular field, economic advisors, and so on and so forth. So, I mean, most publicly traded companies look for a good mix of people. They look for people both within their corporation and outside. And that's where we get the names inside versus outside directors. Right? Inside directors are members of board of directors that are actually also officers of the company. Right? So you could have the president also serving on the board. And you might say, well, isn't that a conflict of interest? Maybe, but it doesn't have to be. And why is that desirable in certain respects? Because sometimes you want a mix of people that are involved day to day, and you want you're thinking about steering a ship, and you want the right mix of inside versus outside directors. And how many directors are on a board of any company? Depends on whatever the bylaws and articles allow. You don't want too big, you don't want too small. Typically 10, 12, 15, 8, whatever.
Does it have to be even or?
No, usually odd is a better number because it's a deciding vote. But it doesn't have to be. And how many inside, how many outside is up to a particular corporation to decide. You can change, you can amend over time, but it's hard to do. But, if insiders are corporate officers, who are the outsiders? Well, they're ones that are not. They could be anyone with expertise that has something to, they could be government officials, they could be directors of competitors, usually not competitors, because how are they going to wear two different hats? But industry leaders, thought leaders, experts, environmentalists, employment, whatever you think will bring expertise to the board, right? That's what inside versus outside, and that's the composition of the board is strategy right there, isn't it? How long should these board of directors serve? Term of office? Well, corporation decides. Do you want a 10-year term? Well, in a way, it's easy. But in a way, it leads to, business as usual. You don't get innovation, right? If you set it too short, you don't give the person a chance to do anything. If you set it too long, you give them, you make them stale. Right? So again, that's a decision that you want to make as a corporation. Then these are key decisions. 4-year terms, 3-year terms, how often do they come up for election? How often can they be reelected? All of these things. And the one thing that most corporations want to do is they want to stagger it. Meaning, if you have 11 people on the board, you don't want all 11 to be elected at the same time so you get a fresh crop. It's like you want institutional knowledge. You want to stagger their terms so that at annual board meetings, only 2 or 3 people are coming up for election at any particular time. So you get that institutional knowledge going, right? So again, we could have a whole class on corporate governance and just this topic. Our goal here is to just understand the difference between inside, outside directors, the fact that they're elected for a particular term by the shareholders within that company. What does the board do? They meet. They have meetings. They talk. I don't want to minimize what that is. Obviously that's important. Regular meetings at regular times and places, special meetings, so on and so forth. Again, they're decision makers, policy makers. They have, I'll come back to that word that I love, fiduciary duties. Meaning the duty to act in the best interest of the company. And if you're not meeting regularly, how are you doing it? If you're not investigating, if you're not reading the reports, if you're not constantly involved in that, how are you meeting your fiduciary duties, right? To the extent that the board is going to make a decision, remember the word quorum comes up again, right? Shareholder votes don't count unless you have a quorum represented. Well, if a board is meeting, but there aren't enough directors present at the meeting, the action that they take cannot be binding, right? So I picked a number like 11. I have 11 board. In the Articles of Incorporation, we might say we need a majority to constitute a quorum. What is a majority of 11? 6, exactly. So without 6 present, we can't even have a meeting. We can have a meeting, but we can't vote on anything that has any binding effect. So you could do all you want with odd versus even, but you can have a meeting with 6 people voting, you still might wind up with a tie vote, right? So you can't play these numbers perfectly. But again, these are, this is governance. This is like running a mini little corporation. And there's a lot involved in corporate governance. But we need to move on to the next set of players, the last set of players, and those are corporate officers. And every corporation doesn't have the same number. There's not, used to be it was president, vice president, secretary, treasury. That's not how, we are. We're CEO, CFO, COO, marketing, and, the world is changing. How many corporate officers, again, how complicated do you want to make it? How big is the company? How much do you want to get bogged down with this bureaucratic business? How many officers do you want to have, and so on, is up to each company. And who are the officers? They work for the company. They're employees. But they're employees' agent, right? They bind the company. They're the upper tier management of a company. They manage day-to-day operations, not single-handedly. There are people that do it for them, but the buck stops with them, right? They are a CEO, CFO. You're basically responsible for what your people that you delegate duties to are doing on your behalf. And how do you get your job? Well, you serve at the pleasure of the board, right? Meaning you're appointed by the board of directors. So in a way, you sort of think about it, shareholders elect the board of directors appoint the corporate officers, right? That's how this little system of governance actually works. How much authority does a particular officer have? What can a COO do? What can a corporate secretary do, or a treasurer do, or so on? Well, that's defined under the governing document of that corporation, the bylaws of that corporation. Remember we said that a corporation can commit an ultra-virus act, right? How does it do that? Well, if a corporate officer acts beyond the authority given to that individual. Everyone with me? Another little diagram as if we needed. Yes, shareholders own the company. A corporation, officers manage the day-to-day operations. Indeed. We talked about fiduciary duties in agent principal. We talked about fiduciary duties with partnerships. It's the same stuff. We'll talk about them with LLCs as well. It's the same stuff, except the players are different now, right? Who has fiduciary duty when we talk about a corporation? Well, forget who for a minute, but what is it again? Well, fiduciary duty is those duty of loyalty, obedience, care, owed by whom? Not shareholders if all they are shareholders. Officers and directors. Officers and directors to whom? To the corporation and shareholders. It's a duty to act in the best interest of the corporation, right? Duty of obedience. I think obedience is misspelled. How embarrassing. Duty of care. Duty of loyalty. So again, we've talked about what the duty of obedience is, to obey, is to follow the law. A duty that directors and officers of a corporation have to act within their authority, right? And where do they get their authority from? What does the state corporation law allow them to do? What does their own articles of incorporation say they could or could not do? What could the bylaws say? What about their own resolutions? People make up the structure and then say, well, we've seen this, but I'm not bound to it. I'm above it, right? That's the issue. And, we're talking about huge egos here along with everything, right? But a corporation is a legal entity that gets to have rights and privileges if it works within the framework that has been created for it, right? So duty of obedience is to follow the law that is applicable to officers and directors. Breaching that duty leads those individuals to be personally liable. And by the way, we talk about a case that comes up, but oftentimes to attract people to a corporation, to serve on the board of directors, to be a corporate officer, is asking them a lot in many ways. I mean, you're compensated at gazillion dollars, but on the other hand, you're also leaving yourself open for liability, because what if, inadvertently, through negligence, you breach one of these duties? Then what? Well, the way that works, and we see it in one of the cases that comes up, is sometimes within your articles of incorporation you say that officers and directors are not personally liable for acts of negligence, for example. Or more importantly, corporations have to purchase insurance, what is referred to as directors and officers malpractice insurance. Expensive but necessary to say that there is a pool of money for not willful conduct, but negligence, right? Bright people sometimes do make bad judgments for which a third party might say you're negligent. Now, are we personally liable? If that's the case, then I don't want to ever serve on a board, right? So corporations have to figure out a way to make it attractive to have those people serve on boards. Yes.
Are bylaws usually very high level, or are they general? Or
Can
very
be
specific?
can be either way. It depends. And that's a strategy too. There's no one size fits all. And there can't be. What's the corporation? What's the issue at hand? I would say as an advisor, you probably don't want to get very specific because minutia will hurt you. But on the other hand, not giving enough details makes the whole provision meaningless. So it's there's an art to crafting bylaws.
Because if they felt like because officer does something and it's just not well defined within the bylaw,
Correct.
it's sort of outside of it.
Then, yeah. So, the question is a very legitimate question. It's like, well, how detailed should the bylaws be or not be? Because either way and the answer is, it depends. And that's what, bright people struggle with as well. And and I just come back to that thought should be given to that. And maybe if the bylaws are too constricting, that they ought to be amended. But the problem with amending is now you need a voting, to vote. So again, this gets complicated. Look at our own country, and we talk about senates and filibustering and all of that. A lot of the very things that make governance and we put in these systems in place actually come back to haunt us in certain situations when you can't get business done. So I'm sorry I don't have an easy answer to that, but I think it's a very good question, and it's something that is a struggle. Duty of care. What is duty of care? Duty of care is not to act negligently, right? So it's a way in which we expect corporate officers and corporate directors to take action in a reasonable way, in an educated way, as if they were acting for themselves, right? So if I was going to spend some amount of money, I would do due diligence, right? If I was going to hire a contractor to work on my house, what would I do? Well, I would, look them up. I would go to Angie's List, get some recommendations. I would ask for references. I would blah, blah, blah. Well, if it's the same thing, corporate officers and directors are engaging someone to do work on behalf of the corporation. You don't write a blank check to to someone that you know to give them business without doing due diligence. You look to see how would you, what kind of care would a reasonable person do, put in if this was their own money. If this was something that they were acting in their own interest, So that's really what we're looking at. Due diligence, duty of care when they're acting on behalf of the corporation. Otherwise, again, there might be personal liability. And I love the next rule. It's not just I love it. Corporations love the next rule. It's a very important rule. And you might say, well, business judgment, where does that come from? Delaware cases. We're at the pioneers for coming up with something. Look, you could make a decision today that winds up being the wrong decision. And corporate shareholders are suing the company because directors or officers breached a duty. Well, the thing is, hindsight is always 20/20, right? The question is, would a reasonable person exercising reasonable duty of care, reasonable duty of obedience, still have made a decision that in hindsight winds up being wrong? And if that's the case, they should be protected under the business judgment rule. And what the business judgment rule says is, look, if a director or officer acts in the best interest of the corporation and made an honest mistake in judgment, then they are protected and are not liable, right? You're not going to use hindsight. For example, the book had an interesting example. What if a car company decides, we make more money. We would make more money. And this is a decision that a lot of companies made 10, 15 years ago on not just producing mid-size economy cars, but SUVs, because people like SUVs and bigger vehicles and so on, right? So we're going to shift operations and we're going to take a gamble. And, it's 1999, let's say, or 2000, and we're going to produce all of these large vehicles. What happens? Price of gas shoots up a couple of years later. It's 2001, and we've had the September 11th tragedy. And, we've got all kinds of issues where all of a sudden gas used to be 99 cents a gallon, and now it's, $2.50 a gallon. I don't know what gas was like 10, 12 years ago, whatever. Now people say, wait a minute, we don't want those SUVs. We don't want Hummers. We want smaller cars. Are you going to hold directors and officers liable for a judgment that they made that in hindsight turned out to be the wrong decision, when what they were trying to do actually was to increase shareholder value? They thought that bigger cars, bigger profits. That's what the consumer wants. And the data seemed to support that at the time. So again, the business judgment rule was crafted by the courts to actually protect directors and officers from making honest decisions that turned out to be wrong in hindsight. And we'll talk a little bit more about business judgment as we go on. So again, not liable for honest mistakes in judgment. And we've talked about duty of loyalty, right? I mean, you can't act as an officer or director against the interest of the corporation. If I put my personal interest first, meaning I hire, I'm on the board, well, I'm just going to give business to my family members. They might be the best company, but did I disclose it? Did I engage in any due diligence? Did I look at other people to see if the corporation could actually get a better deal from another company that I could hire? Well, those types of things are breaches of duty of loyalty, because I wasn't loyal first to the corporation. I was loyal first to my own personal interests, which again could make, making those kind of secret profits or things like that could make a director or officer liable. And again, we've talked about taking a corporate opportunity that you first should have given to the corporation, self-dealing, unfair competition, competing against the very corporation that you serve, so on and so forth. Any of those profits, again, you could disclose it. The board knows it. They do their due diligence, and they still think that the best company to go do business with happens to be a company that's related to one of those corporate officers or directors. That might be okay. But again, loyalty is, whether or not it was breached is again determined by the facts involved and whether or not there was disclosure, whether or not there was due diligence. Convoluted case, this one, fiduciary duties of, this was a case, I couldn't even get the facts straight. But let me just sort of boil it down for you. This was a corporation that within its articles of incorporation had written in that corporate officers or directors would not be liable for negligence, either ordinary negligence or gross negligence. And presumably they had, enough insurance and so on, so this wasn't sort of violating some state code or whatever. So what happened here was you had someone that actually was on the board, and you had, so the cause of action was being brought against one particular, if I recall correctly, member of the board, this guy Sidhu, and the entire board for basically, this involved, I think this case involved sale of, say that again, buying another company? Selling, yeah. Right, so as a board, you're looking at different offers that are being made, and you got an offer $25 million, and you chose not to go with it, and you chose to go with something else. And at the end, the shareholder lost value as a result of decisions made by the board, and in particular, decision made by a particular member of the board. And now the notion is, well, are they liable? And the court has to look to first see whether or not the articles of incorporation protect any of the defendants. Yes, so within, oh, that's right. And then he sets up his own company. Thank you for reminding me of that. So this one bad player, so one can, I'm no genius, but so I can surmise that from that, the idea was that he wanted to profit himself. And, not so, and that's where the court sort of comes out. They said, look, a corporation is free within its articles of incorporation to absolve, meaning to not hold responsible certain members for negligence, right? And if that's the case, and in this case the court says we think it might be gross negligence for a board not to question these decisions, but guess what? They're protected. That's in the Articles of Incorporation. All right? So a large number of the board of directors were actually protected here. However, this one bad seed, this one individual that sort of went beyond, to sort of perpetrate a fraud almost, the court said, no, no, no. That's bad faith. That's not negligence. Negligence is oops. Should have known better, should have done better, didn't do better, right? Bad faith is intentional fraud, and the court says, no, you can't ever make not someone liable for intentional fraud. This guy is probably responsible based on this backdoor way in which he was getting his, getting funds from this corporation funneled into his privately owned corporation. That we're not going to stay, that we're going to motion to dismiss is should the lawsuit be dismissed against a particular defendant. And the court said no, we're going to go against this particular defendant, but because the others are protected for negligence. So that really was the convoluted facts, and that sort of brings about, this example that I gave about how does a board, how does a corporation attract people? Well, they sometimes say no negligence liability. We'll have enough insurance to protect. You're not going to be personally liable, even if you basically breach a duty of care, which they did here. Negligence means breaching a duty of care. Everyone knows Sarbanes-Oxley? How could you not? As future accountants, as future auditors, there's so many facets to it. The reason I bring it up here in this chapter is basically to say that Sarbanes-Oxley has a number of provisions relating to corporate governance as well. Obviously, we know the law was enacted by Congress in 2002 with the goal to have a better handle on corporate governance, to eliminate sounds like a big lofty idea, to decrease conflicts of interest, to have, we saw what happened after big public companies came to light with all these kinds of frauds and so on, to instill public confidence. We know that's the goal. But so what are the kinds of things that Sarbanes-Oxley did? Well, it sort of eliminated, you can't have conflicts of interest, you can't loan money to corporate officers and directors, you can't have this revolving door where one person works for one company and then goes and works for the auditing firm and so on. Again, measures where you would hope that you would have fewer of Enrons and Tycos and all of these companies that became the reason why Sarbanes-Oxley was enacted in the first place. And the last point I wanted to quickly make was another law called the Foreign Corrupt Practices Act, which is a federal law that basically says that U.S. corporations may not, acting through its agents, officers, directors, bribe officials in other countries in order to conduct business activities. Sounds good? What's that? I'm sure they do is one response I'm getting. But you could be a very upstanding corporate officer or director. The problem is when you choose to do business elsewhere is that the argument, and again, I'm not saying I agree with it, the argument is we can't do business elsewhere unless we grease a few palms. That's legitimate over there. It's expected. I'm never going to get a permit if I, just file the paperwork and wait. So this is sort of another one of those contentious things that, does the government always enforce it? Because it's like, yes, we want to be portrayed as never, ever, never, it would be. But on the other hand, what are the choices of a country that has operations in a particular place where that's a norm? So again, yes, technically not, practically, who knows? Is it ethical, not ethical? And we'll talk a little bit about that as well. Legal versus ethics, that's, again, one of the things when we talk about corporate responsibility and, and so on, and we'll come back to those concepts, but keep that in mind. All right, we ended early, 20 minutes early, 25 minutes early. You're welcome to discuss.